close, the judges have 15 days to make a decision. So the time frames are really fast here. And as a result, one, you keep the costs down, which I think is pretty good. But on the other hand, it's not like you build the largest and most extensive record for, frankly, what are oftentimes complex constitutional issues. So the administrative courts can hear and resolve as-applied challenges. Interestingly, the Court of Appeals can, on the same case, can consider a facial challenge, even though the facial challenge can't be brought, or at least resolved, I should say, in the lower courts. So sometimes that creates a pretty sparse record for a Court of Appeals and a bit of a challenge. But in my view, I think that's what's happened is because these campaign finance laws can be very complex and very difficult. Let me address the issue committees things real quick. I think my chart doesn't handle issue committees. But the way I would look at it is you've got contributions, express advocacy, and electioneering communications. Well, an issue committee is something that expressly advocates for or against an issue. And because we don't have corruption, you can't corrupt an issue. You don't have contribution limits. So you have unlimited contribution limits for an issue committee. You don't have any source restrictions, but you do have disclosure requirements, and that's really where a lot of the heat and litigation around issue committees has been. I'm sure people are familiar with the Sampson case. That was a small issue committee, and the Court of Appeals, which frustrated me to no end, said, look, the state doesn't have an interest. Remember, there's three interests for disclosure. One is to help enforce campaign finance laws. Well, you don't really have much enforcement in issue committees because there's unlimited contributions and unlimited sources. So what the heck are you enforcing? So that's a weaker requirement. And you don't have any efforts. Part of the disclosure isn't to help prevent future corruption by showing you what the quids are so you can match that up with the quos in the future. So you don't have that interest. So you're only left with informational interest, giving voters the level of information they need to evaluate that. On the other side of that equation, the harm is, look, just because I give $20, now I have to be reported to the government, issues of retribution, issues of kind of complexity, and how difficult it is to comply with this stuff. So what the Sampson case said is, well, the 10th Circuit said, well, look, for these small issue committees, they only spend a little bit of money, there's not that much of a governmental interest in the disclosure, and that's outweighed, frankly, by these harms, these burdens that are placed upon expression and the complexity of filing and all that stuff. So the state can't regulate small, there's a line under which the state cannot regulate small issue committees. And we're not going to tell you what that line is. That line exists somewhere in the ether, and we're not going to tell you what it is.
But there was a Secretary of State, as I recall, who tried to define that.
A bold and vigorous, proactive Secretary of State, seeking to provide clarity and allow people to express their First Amendment rights without fear, stepped into the fray. And so we passed, when I was Secretary, a regulation that said $5,000 is the limit. And we did all of this analysis on, what size of issue committees there were out there and sort of what was the distribution and all of this stuff. And we came up with $5,000. And the court struck that down, saying that's bad, well beyond your authority. And by the way, the Constitution doesn't allow it, so you can't do that. So then it went back to the court, and I think Matt Grove in particular was defending a case. And the judge said, so what you're saying is you want us to either uphold it or strike it down entirely. And I think you said either, free us or put us out of our misery.
Execute me now. I was in court that day on another case. Matt brilliantly stood there and said to the 10th Circuit panel, execute me now or set us free.
Right. Well, I guess execution would have been a form of setting you free.
Well, the point being, and we're going to interrupt each other a little bit, but I guess, Matt's point, I think, is a very good one. This is a quandary we get into. Unless one of these provisions that we've been talking about is struck down facially, either allowed to go forward, that's the set me free piece, or struck down facially, which is the execute me now piece, so we're done with it. It gets decided on an as-applied basis, which means that case is resolved, and the next guy comes in the door, and it's going to be me with a case. And it's a 1983 case for which I get attorney's fees if I win, and I'll win because that's the drift of the constitutional law at that point coming out of the Supreme Court. That will have to go up. No, he's going to lose the case. He has to defend it on behalf of the state of Colorado. He does. The state loses, pays my fees. The next guy in the door as I'm going out is Scott, representing one of our opponents, saying, hey, it applies to me, another 1983 case. So until we can get some resolution, somehow, either as a more broadly applied, as applied challenge, and I want to come back to that in a moment, because this is a concept that is developing, so that we know who's on what side of the line, or we have a legislative fix if the secretary is found not to have the power to change the law administratively on his own behalf.
So in this case, there wasn't a legislative fix because the court did not execute and did not set the office free. Said, well, sorry, that's just the way it is. And so despite that frustration, so the legislature did step in, and they created a limit of threshold, which was $5,000.
So Scott is vindicated on principle, but not on power.
Yeah, but here's another thing about that I find interesting in campaign finance law. So part of the reason why that $5,000 threshold didn't originally exist is because it conflicted with the Constitution, which holds no $5,000 for the threshold. Well, the legislature creates a $5,000 threshold, which, frankly, conflicts with the Constitution. Now, is that going to be
arguable?
Conflicts.
Hold the thought.
But I think what's going to happen is no one's really going to say anything about that, because it's really stupid to try and strike that down and go back to this morass. And I think a good example is the definition of an issue committee. So under the Colorado Constitution, the definition of an issue committee is very clear. It says you either have a purpose, have a major purpose of supporting or opposing a ballot issue, or you spend $200, collector spend. You do one, or you do the other. It's an or, okay? It's not and, it's a or. Now, the secretary passed a regulation saying, well, it's really and, okay? It's really and. And I, the other day, doing some research on a case, spent a lot of time looking at this. And you look at all of the courts, all the administrative courts, all the courts of appeals. They never say, well, the secretary has the power to do that. They never say that. They simply say, the secretary did this, and we'll go along with it. That's what they all say. So it's sort of like, well, let's just not go there to see whether or not we should really, there's a direct conflict. We'll just accept that and move forward, because otherwise it's an insane interpretation, or it's an insane application of the law.
Now, let me weigh in there, because this is an interesting area that I think is going to be upon us. In the case we were just talking about, Horvat stood there and begged to be executed so that he wouldn't have to continue to spend state dollars defending these cases. The court in, what was it? Trying to remember the plaintiff's name. Coloradans for Secular Government or something? Coalition for Secular Government v. Williams, when it was finally decided just this past spring, came out with an interim level. They were dealing with an issue committee there that I think was at the $3,000+ level, a case that began before the legislature acted this year. There's a footnote in that opinion that refers to the provision that we're all familiar with, and that Scott just referred to, and that is this or versus and. The Secretary of State rule that converts or, in other words, issue committee either accepts money and makes expenditures supporting or opposing a ballot issue, or / and, whatever you want, has a major purpose. That Secretary of State rule goes way back, and I don't know which Secretary of State adopted it, but there's
I think it was almost immediately after Amendment 23.
I think that's probably...
I'm sorry, Amendment 27.
27,
Yeah.
I think that's probably correct. And there's a footnote in the Coalition for Secular Government case where the 10th Circuit Court of Appeals says we don't accept that, based on exactly the principle that Scott's expressing some frustration with, and that is the structural inability of a Secretary of State to adopt a rule that facially conflicts with either a statutory or a constitutional provision. Now, Scott could argue that, hold that thought, because I'm not sure we can resolve that today. Actually, Colorado Supreme Court has kind of resolved that in some other context for our purposes. But the 10th Circuit tossed that out there. And by the way, while, as Scott says, none of us in our right mind make much of an issue of that, I think vis-a-vis each other, because we don't want to get into that quagmire. There are people who do. We have local governments in this state, which is not a concern so much to our administrative law judges, because you don't have to deal with them. I do, unfortunately, but you don't. But who disregard that and disregard the major purpose test. They adopt, under their home rule powers, provisions that require entities that have been around for years and years and years, if they get involved in a ballot issue. Yes, Matt?
Go ahead.
No, I was going to say, weigh in. I think they adopt provisions that require you at least to do something, not report at the level that would be required under the state campaign finance laws, but to file and register. Secondly, there are people out there, given our private right of action, the private complaint mechanism, who could very well bring that kind of case. And I think we all have, I don't know if some legal frustration with that, but practical frustration, because it's coming. And that the treatment of the major purpose test, the survivability of the major purpose test, that or versus and issue is on its way in the door. I can guarantee you.
Let me talk a little bit and pick
Matt,
up.
if Matt wants to say something, I would invite him, by the way.
Matt, you're more than welcome to.
You're the guy on the ground.
we're
Just
among
talk
friends,
loudly. As a matter of fact, let me give you the microphone.
I was just going to say two things. One, I know the 10th Circuit said that in the CSG case in the footnote. I don't consider that binding unless it comes from a state court. And two, I think it's inconsistent with the 10th Circuit's own precedent. The genesis of this and/or distinction comes from a case called Colorado Right to Life, Committee versus Kaufman, which Mork and Iser litigated back, I think, just after Amendment 27 came out. And in that case, the plaintiff, which was a small ideological issue committee that wanted to spend money more than $200, challenged basically the or and distinction, and Morey's argument was that $200 is a proxy for major purpose, that those two things go hand in hand, and the 10th Circuit said no, it's not, and it's unconstitutional to treat it as such. And so if it can't be a proxy, then you've got to have both. And so I think that in that Colorado Right to Life versus Committee versus Kaufman case, we got an even clearer, a less murky distinction than we got in the Sampson case. And so I think that we would have a better argument in the event that some sort of rulemaking challenge came up. But right, there are questions about our authority to do it that have not been answered by the state courts.
Let me change a little bit and sort of pick up what you had talked about with respect to the as-applied challenges. Look, from a litigant's, and I'll adopt sort of the litigant's or compliance standpoint, non-official, but like the people out there trying to apply this law here, or comply with the law here, I should say. I sarcastically say, and I have said this to clients, you pays your money, you takes your chances. Here are some of the challenges I think that exist in this. First of all, we have a complex area. You've got the Article 28 is hardwired into the Constitution. You've got this overlay of the First Amendment. Okay, some of the other things that make it difficult. We've already talked about the private enforcement action, or as I call it, the modified bounty hunter system. Okay, so enforcement is exceptionally uneven. It really depends on the political context and the vigorousness or anger of your enemies and the amount of money they have to sue you. So that's, the enforcement itself is is very uneven. Secondly, let's talk about the Secretary of State's rules. So one of the, I think, challenges I had as Secretary is trying to create a rational set of rules that can be evenly applied across the board. That has a few problems. One is, courts of appeals are hostile towards that. Even when there's, in my view, directly on point U.S. Supreme Court case law, you can't pass a rule that complies with that Supreme Court case law. So there's a level of rigidity built into it. Secondly, administrative law courts, frankly, have never said, nor have a court of appeals say, that the Secretary's rules and regulations are binding upon administrative courts. I think that is still an open issue. And you certainly see it in that dual enforcement area, where the Secretary of State follows a certain set of rules, but courts will apply a different calculus oftentimes in assessing fines and penalties for lateness. So you do have sort of that tension there. And certainly the Secretary of State's guidance itself, non-rule guidance, if someone calls up and says, hey, what should I do? You know, and the Clear the Bench case was sort of the prime example of it, where the Clear the Bench comes to the Secretary of State's office and says, what should I do? Should I be an issue committee or a political committee? And the Secretary of State says one thing, of course there's a lawsuit by the enemies, and the courts come out in a different way. So people seeking to comply rely upon the Secretary of State's interpretation and guidance at their own hazard, basically. And you've seen this in the advisory opinions, like the Citizens United advisory opinion, the Republican Party advisory opinion. They come to the Secretary of State and they say, hey, give me an advisory opinion. The Republican Party is probably the best example. Secretary of State, give me an advisory opinion. Can I do this or not? And for the Republican Party, the Secretary of State, we think you can do it, but I want you to know, our advisory opinion is utterly worthless. It is utterly worthless. You have to go to court. So that's what the Republican Party did, is they went to state court and got a declaratory judgment action. So you got those conflicting areas or lack areas of authority due to this concurrent jurisdiction setup and the private right of enforcement. The other thing that you've got is, you know, the as-applied challenges, which I think are sort of in some ways a safety valve to say, look, let us stop the insanity in these instances, create a set of laws that are already riddled with challenges, create ongoing sort of Swiss cheese challenges, because you poke a hole in it here, but then we all argue about how big is that hole, how big is that applied challenge, or how small is that applied challenge. Sampson case was a perfect example, or Simpson case was a perfect example of that. How big is an as-applied challenge? So one argument was, well, the as-applied challenge is just to that issue committee only that litigated the Simpson case. My argument was, well, no, that as-applied challenge applies to a category of litigants that come under a certain unknown threshold. Okay? I think one of the unappreciated areas of Citizens United case is a sort of very interesting analysis on as-applied versus facial challenges. Because in the Citizens United case, what happened is, Citizens United tried very hard to avoid the constitutional box and just focus on the statutory box. And then when they got sort of pushed into the constitutional box, they tried to have a very small constitutional box, just an as-applied challenge, rather than a facial challenge. Because we all know facial challenges are the hardest to win. Constitutional challenges are harder to win than statutory interpretation challenges. And interestingly, when you read that case, the court said, no, you lose under statutory. And no, we're not even going to look at the as-applied. We're going to go to facial. And the other side said, well, but Citizens United, they abandoned their facial claim. They're not arguing facial. How can you as a court say it's facially wrong? And the court said, look, as applied versus facial, that's really a continuum. It's a